Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
In April 2022, the ABA Antitrust section convened its 70th annual spring meeting, bringing together over 2,500 practitioners from the U.S. and abroad. It was a unique opportunity for our Curiosism to interview several of the international enforcers live, including from South Africa, Mexico, and Chile. Here's what they had to say.
My name is Anora Wang. Today, I have the pleasure to speak with John Simpson, tribunal member of South Africa's National Consumer Tribunal, or we would just call it the NCT. Very happy to have you, John.
Thank you.
So may I just do a little introduction? So Advocate John Simpson is one of two full-time tribunal members with the NCT, which is a South Africa agency that focuses on fairness and justice in the consumer and the credit market. And the NCT is an independent adjudicative entity that hears cases and its decisions has the same effect as one made by the High Court of South Africa. So like a court, the NCT would hear cases from consumers or referred by other agencies. John has been with the NCT for the last 10 years. We're very happy to have you.
No, thank you for having me.
John, just some very high-level question. What is your top priority for the next year?
Well, look, we want to focus on trying to finalize our cases as quickly as possible. So in South Africa, and I think worldwide, access to justice is very expensive and takes a very long time. So one thing we've been trying to focus on is bringing justice to the consumer faster, more efficiently, and in a more productive way, so that you don't wait for a very, very long time before you have a conclusion to your case or your problem. So that we've been focusing on, and largely we've been successful. We're at least faster than the courts in South Africa, which we're very proud of.
You should be proud of that. Just approximately, how many cases do you hear a year?
Well, we have two major sections of cases. The one is debt review applications. So these are people in financial distress that need an order to prevent their creditors from attaching their assets, and they repay a certain amount per month. So it makes them more productive members of society without being liquidated or sequestrated. So of those, we have about over 30,000 cases a year.
Wow.
And of the other major cases where we're talking about fines against firms, companies that don't comply with the National Credit Act and so on, overcharging on fees, those we have approximately 300 to 400 a year.
Mm. Has the caseload or the speed of a speed of adjudication being impacted by the pandemic at all?
Actually, no. Amazingly enough, we managed to learn very quickly that we can actually hear all our cases via audio and video transmission. So in the beginning we used Zoom. Now we're using Microsoft. This is not an advert, by the way. Now we're using Microsoft Teams.
Right.
And it's worked really well. We've actually found that only in the minority of cases do we need to actually go into court and have everyone appear physically and hear the parties physically. 90% of our cases we can actually do audio and visually, and it's been working very, very well for us. And we actually found that we're actually able to continue seamlessly throughout the pandemic, which, again, we're very happy for.
That's good. Do you think the virtual element is going to stay even after pandemic since it's so convenient?
Yes, it certainly is. I mean, we occupied 2 floors in our building at one stage. And as it happens, I no longer have an office anymore. We were actually able to hold or to do away with half the office space.
That's
so
great.
we function with half the office. Only half the staff need to be in at any given time. 90% of our cases held virtually. So it's really working well. So I don't see any reason for us to go back to physical sort of face-to-face interaction as such.
I agree. So as I mentioned, the NCT focuses on consumer and credit markets,
Yes.
right? So what is the most important trend that you have seen in consumer protection generally, or focusing consumer credit more specifically, that it would develop perhaps over the near to midterm?
Well, what we're seeing in South Africa at the moment is financial distress. And it's being made worse by obviously the local conditions or the global conditions in terms of the Ukraine, energy prices increasing. The South African consumer is really suffering. So what's happening is that we're seeing far more applications for debt review. That's over 30,000 cases a year that I was talking about. So we're getting a lot of people applying for debt review. And we're increasingly issuing orders for placing people under debt review. And that's concerning. The fact that the middle class in South Africa is definitely suffering, definitely finding it very difficult to repay their debts. So we're seeing that debt review process and number of cases increasing there. Then on the credit market side and the consumer side, what we're seeing is car disputes. We also deal with car purchase disputes. You buy a car, it breaks down the next week. And the dealer refuses to take back the car.
Oh, wow.
We're seeing a lot of those disputes and a lot of those cases come up. So, and in South Africa, it might be different overseas or over here in the USA. Cars are enormously expensive in South Africa because they are taxed to death by the government before they come in. So basically, cars are extremely expensive. So it's a very costly exercise for a person to buy a car and then not having it function the week after. So those sort of disputes have a huge financial impact on consumers in South Africa. So we're finding a lot of those cases happening.
Oh, wow.
And then on the other aspects we're finding is credit lenders in South Africa have to comply with the National Credit Act in terms of the information they give, the information in their contracts, the interest rate they apply, and the charges that they apply as well are limited by the Act. And we find lots of credit lenders flouting the provisions of the Act because of people's desperation.
Right.
So people are very desperate to get loans, so they go to unscrupulous lenders who charge exorbitant amounts.
Which is usually in small print, right?
Well, they don't even have to be in small print. These people are so desperate, they will accept a loan that's charged at 30% interest per month, which is totally unlawful, obviously. And they accept that. And then the credit provider will actually take judgment against them for a loan that was taken out, let's say 500 Rand or 1,000 Rand, that has escalated over a period of 6 months to a year to 30,000 Rand.
Right.
Just like that.
Wow, that's too
very
bad.
scary.
Are these people usually represented or more of like a pro se, like they would appear in front of you?
Well, in terms of our process, they would first, the regulator, which is the National Credit Regulator, would first investigate. They're the enforcer of the regulatory enforcement body. They would first investigate. If they find wrongdoing there, then they will issue summons against the firm or the credit provider and bring them before us. And then we can fine them or deregister them or whatever the case may be, and also order reparations.
Right.
We can order that all the overcharged interest and fees actually be refunded to the consumers.
Right. Earlier you mentioned that the caseload seems just unimaginable, but you must have seen many practitioners in front of you. Do you have any tips that you would have for practitioners who want to be effective in front of you?
Well, look, obviously, yes. We see a wide spread between your very famous litigators in South Africa and then your lesser-known ones, your one-man show type of practitioners. Obviously, what you get in terms of the high-level practitioners is they get a lot of support in terms of teams assisting them to research the case law, to understand the principles which apply, and so on. You'll see in your lower end market, for want of a better description, in terms of the litigators, they don't have that sort of support. They don't have the time to do the research. So what happens is they are often broadsided by arguments raised by the regulator which they have no clue how to deal with. So, preparation is key. It's a very highly specialized sort of arena, highly specialized field of law. If you're not on top of it and know exactly the case law, know exactly what's happening lately, having read the tribunal decisions, you're going to get lost.
Very good advice.
So I think in law, as with anything, it's very difficult to be a practitioner of a wide spread in a wide arena. If you don't specialize in something, you're going to be facing problems.
Totally agree. So we also want to learn a little bit about you. So
Sure.
Do you have any interesting hobbies or accomplishments outside of consumer protection law that you could share with us?
Well, look, I enjoy golf. I'm a total golf addict. So the fact that the Masters tournament is on at the moment, I wish it was next door because then I would definitely pop in there. But golf is one of my passions. I certainly enjoy that. Motorbiking as well. I haven't seen many motorbikes here in Washington, which is unfortunate. I was hoping to see the latest and greatest.
Probably a good thing, though.
So I'm a speed freak in that regard. So from one extreme to another, slow golf to fast biking. What can I say?
That sounds enjoyable. Yeah.
I certainly do enjoy it.
Well, thank you. It's our pleasure.
Thank you, Anora. Appreciate it.
Yep.
I'm Alicia Downey, and with us today is Brenda Gisela Hernández Ramírez, who is the Commission Chair of the Mexican Federal Economic Competition Commission. Welcome to our Curious Amalgam.
Hi, Alicia. Good morning.
Hey, we have a few questions for you, and the first one is, what is your Commission's top priority for 2022?
Yes, thank you for this question. My priorities in this year and in others to come are to continue reaffirming and consolidating Commission's importance in a challenging environment where the President has refused to select candidates for the 3 vacancies that we have, which are supposed to be 7, and we are only 4 in the Board of Commissioners. When this government introduced legislative proposals to reduce competition in key sectors of economy, such as energy sector, we have to act, and I think that's my priority, to continue guaranteeing promotion and surveillance of competition in the strategic sectors. And in fact, last week we just released some program. It's like a strategic plan from the 4 years to come, and we have decided to go in different specific sectors that are really important in my country that we want to protect in competition, like public procurement, health, financial, food and beverage, energy, transportation and logistics, digital markets, and as well construction and real estate services. So we are going to put all our sources to continue protecting these, and I would say that those are my priority to come.
Thank you. And just looking in the near to midterm, what are you seeing as the most important trends that you're seeing in your competition law enforcement in Mexico?
Well, I see various trends in short and midterm. For example, the COVID-19 pandemic has led us on an unprecedented crisis, and currently the government around the world are seeking to promote economic policies to achieve a strong, sustainable, and inclusive economic recovery through the mix of economic and industrial policies to build back better. Here, the role of competition policy and competition authorities as competition advocates is ever more important, especially when governments around the world are contemplating policies to address economic, environmental, and social goals. In light of this, there's a trend that is increasingly calling out the incorporation of alternative policy objectives into the competition policy framework. At the Commission, we are currently following debates around this discussion because even when our competition law only allows us to protect competition and market efficiency, we have had recent coincidences in which pursuing competition policy objectives resulted in pursuing other public policy goals. Let me say that, for example, we have addressed sustainability concerns through competition advocacy in the electricity sector, given the recent actions taken by the Mexican government to implement a counter-reform in the sector to disincentivize installation and operation of new electricity projects, including those based on clean sources. In this regard, our advocacy study on clean energy certificates estimates that there's an impact in this action and it slowed down investment in clean energy. particularly renewable energy one, which contributes to not meeting clean energy generation goals committed for my country in the next to come. So I think that there's one of these issues that we have to continue protecting. And on the other hand, for example, digitalization continues to be a major global trend.
Of course,
and
yep.
In this regard, there have been numbers discussing regarding possible adaptations to analytic competition tools, as well as on issues where other policies intersect with competition laws, such as consumer protection, data protection, privacy laws.
Very good. Very interesting. Now, we're here at the Spring Meeting Conference, surrounded by people who advocate before agencies here in the United States and all over the world. What special tips do you have for practitioners who want to be most effective in front of your agency?
Well, in front of my agency, I would recommend all practitioners to advise their companies to follow, for example, a compliance program that it's complete and it's thought and tailored for every company that is involved with them as their clients.
Very good. And just in an effort to get to know you a little bit better, do you have any interesting hobbies or accomplishments outside of competition law that you can share with us?
Well, to be honest, I don't have many free time. I have many things to do in my agency. But when I have a free time, I like to go out just with my family. I like to go in open spaces. You know, with this pandemic, what I like to go is just go out and maybe to the beach or wherever. And I like Italian. I am and now retake my lessons. So I will say that.
Oh, that's great. Well, so many of us feel the same way. Thank you very much.
Thank you, Alicia.
With me today is a special guest, Ricardo Riesco, who is the National Economic Prosecutor of Chile with the Fiscalía Nacional Económica. Welcome to the show, Ricardo.
Thank you, Alicia. It's a pleasure to be here.
Well, you're the right person to ask this question. What is your agency's top priority for 2022?
Well, in this difficult context, as a Fiscalía, we have been trying for the last couple of years to try to enforce to its full extent the new attributions granted to the Fiscalía by the last legal reform of our Chilean Competition Act of 2016. Since that date, we are not only like the prosecutors in Chile, which are in charge of investigating and then prosecuting possible cartels or abuse of dominance or whatever, any other unilateral conduct, but we are also in charge of merger control in our country. And we are also allowed to do market studies in Chile. And these two new tools that we have for almost 5 years now have been very effective. We have, for example, in merger control examined for, almost 200 cases during this last 5 years. Around 12% of them are subject to some kind of behavioral or structural remedy. And we have blocked 4 cases. One of them actually is being challenged before the Chilean Competition Tribunal. And in merger studies, we have done 6 merger studies so far. We believe after a market study, we recommend the government to implement some legal changes to promote competition in the markets. If they accept them, we believe, according to our calculations, that either the people or the state could save yearly up to $1.5 billion in our markets. And since we have this attribution 5 years ago, all of our recommendations have translated into bills of law aimed at modifying competition in relevant markets for Chilean people.
So it's been a very busy time, isn't
it? Exactly.
Now, looking ahead in the short term, what do you think are the most important trends that you see in the law enforcement side of things?
Well, that's a very good question, Alicia, and I think we should divide the answer in two, like the international level and at the national level. At the international level, I think that there are 2 big issues going on. First, digital platforms, big tech, and the digital economy in general. As a smaller jurisdiction in Chile, I believe that we are following quite closely what the larger jurisdictions like the US and Europe are doing regarding these platforms, because they are all transnational companies doing business on a transnational level. So it doesn't make so much sense to try to regulate them in each of our countries. They have to have like a global regulation in my opinion. And also, but that doesn't mean that if they incur in any anti-competitive conduct in our country, that we are not going to investigate them, and if necessary to prosecute them also in our country. So we are looking very closely to this evolution. And on the other hand, I think we are going to see big reforms, or at least pushes to big reforms in the merger control systems. We are going to review, I think, at the international level, if the substantial lessening of competition continues to be like the substantive standard that we want to have. Maybe there are going to be like procedural changes as to the standard of proof, as to who has to prove what, as to efficiencies. I mean, we're seeing lots of desires to change that, because we are seeing also an increasing concentration of the markets, right? That at the international level. And at the national level, we are also, as a country, in the process of drafting a new constitution. So we have had like quite severe criticisms to our economic system, to concentration in the markets. And so we expect to have some changes in our constitution that may translate into legal changes. And for sure what will happen is that we will lose like the right or the attribution that we currently have to prosecute cartels criminally. And we are going to share that with our Department of Justice, and this will imply that we will have to collaborate more closely to reach the goal to put people who engage in cartel activities behind bars.
And what is the timeline for the completion of the new constitution?
Well, there are currently 154 people drafting the constitution. They have to propose to our country a new draft constitution by July 5th. And then the general election, saying yes or no to the new constitution, will be held on September 4th. So this would be a year of great decisions for our country.
Oh, that's very interesting to hear. Just switching over to a different topic, something we're asking the other enforcers. Well, what suggestions do you have for practitioners who want to be most effective in front of your organization, either as it exists now or as you anticipate how it will operate in the future?
That's a difficult question, but I would say that, for example, in merger control, the best advice I could give is to try to collaborate, to be as transparent as possible with the authority. Because we have very strict timelines and timeframes to issue a decision when we have a case notification in merger control. So the less information we have, the more time we will take to analyze the case and to reach a satisfactory conclusion, a decision. So, and if they don't file the information, which has happened before, we can go to the competition tribunal and trying to seek the imposition of a fine for not having submitted to the authority all of the necessary information to be able to reach an informed decision on a given merger.
Well, that sounds like it's going to be advice that applies no matter what shape the agency takes in the future. And finally, just to get to know you a little bit better as a person, do you have any interesting hobbies or accomplishments outside of competition law that you'd like to share with us?
Yeah. Well, I used to be a very good, not so good, but pretty good soccer player when I was at school and in the university.
Football.
Yeah, football. Yeah. Now, as I'm getting a little bit older, I mean, I cannot play so much, but I like to watch soccer and football very much. I'm a very big fan of Colo-Colo in Chile, which is like the most popular team. And in the international level, I'm a fan of Bayern München, which is like the most popular and most successful team in Germany. Because I lived in Germany while I was young, so that kind of stuck with me.
Okay, and do you wear their jersey, when you watch the
and
games?
with the kids, yeah.
Of course.
Always.
Okay, well, thank you so much. It was great having you on the show.
Thank you, Alicia.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.